Hello, this is Matt on the Moon Lambeau channel, and good news, everybody! The SEC is officially attacking itself. Indeed, the SEC lawyers, in a freshly filed legal document today, have attacked SEC commissioners Elad Roisman and Hester Peirce, their points of view specifically, that they wrote in this article that's on your screen right here, this piece, whatever you want to call it, which, by the way, is on the official SEC website, and it's titled In the Matter of Coin Schedule. And so the SEC takes issue with some of the specifics in this, and they also contest whether or not these opinions even matter, which is rather shocking and something that I'm going to be talking about in this video. Now, I'm not going to run through this piece as I've sufficiently covered this. This is from July 14th of this year, so just a week ago. But I do want to make sure I properly set the table. So what you do need to know about this piece is that these commissioners, 2 of 5 commissioners, mind you, that vote on whether or not to bring a legal complaint against individuals or businesses, they do not mince words in this. They make it very clear that they're constantly getting asked by market participants for regulatory clarity. They make it very crystal clear that the SEC has not done enough to prevent confusion within the space. And so, you might ask, how is it possible that so many market participants are unclear of the legality of various cryptocurrencies if the SEC has provided sufficient regulatory clarity? Think about that, because with other asset classes that they get to regulate over, you don't have this level of confusion. So, is it the case that the SEC is not doing their job in providing clarity? Or is it the case that it just, by coincidence, there's a bunch of idiots that are in crypto that just are not smart enough to understand what's legally required of them? What sounds more likely? Because there's some really smart people operating in the blockchain and crypto space, right? I think that we'd probably all agree on that. So what's more likely? That they're just a bunch of idiots and don't get it? Or that the SEC, they keep getting all these questions because they're not providing regulatory clarity? It's obvious, right? That's why this is pure nonsense. And so this most recent legal filing, which I'm going to run through today, the SEC attorney that filed this submitted 5 points of view, which I'm going to take to task. And there's a fair bit of hypocrisy on here. Now, part of this is predictable, but part of it is just hypocrisy. All of it's entertaining. So I hope you got your popcorn all popped and ready. If not, you can pause and get some, kick your feet up on the desk and relax here. Uncle Moon Lambeau going to take care of all the specifics for you here. But I do want to be clear, I don't have a legal or financial background of any kind. I'm not offering legal or financial advice, and so you definitely should not buy or sell anything because of anything that I say or write. Now, within the last couple days, we've seen Ripple and Brad Garlinghouse and Chris Larson's attorneys all file documents to the court, highlighting this piece written by Hester and Elad, the commissioners at the SEC, saying, look, this is in support of our defense. We did not receive fair notice, which is crucial because if Ripple didn't receive fair notice, then they win. If the court finds that they did not receive fair notice, this whole thing's over, frankly. And because you can't just not have sufficient laws in place and then let market participants act the way that they're acting for the better part of a decade, and then decide that you don't like that anymore, and then retroactively go back and be like, oh, actually, the whole time you've been doing this, it's wrong, and actually, you should have known that too, even though we didn't come after you. Like, it's just, no. It's complete and that's a real legal argument with teeth. That's why this is all so important here. And so James Filan, who is a member of the XRP community and an attorney, wrote the following just the other day. It will be interesting to see how the SEC tap dances in its responses to the defendant's filings about the Peirce and Roisman statement in view of the obvious infighting at the highest levels of the commission. The SEC needs to put its house in order. Yeah, no kidding. And so don't forget, like, Hester and Elad here, these 2 SEC commissioners, they are among the highest ranked people in the SEC. There's serious infighting here. No kidding. And then on this topic, Jeremy Hogan. So this comment was also before what I'm about to get to today, but just setting the table here. This is good stuff here. Because there was a tweet here from James Filan, attorney James Filan, XRP community member again, he was sharing the I think this was Ripple's document, right? Yeah, this is Ripple filing supplementary document here in the support of their fair notice defense. And so James K. Filan shared that legal document, and then Jeremy Hogan, who runs the YouTube channel Legal Briefs, who is a XRP community member and an attorney here, he retweeted that and wrote the following. And he's citing attorney Kellogg, who is with Kellogg, Hansen, Todd, Fecal, and Frederick. That's a very lawyery sounding name. So, representing Ripple, though. So he wrote, attorney Kellogg understands how great this argument is going to be. If a reasonable person doesn't have any clarity in July 2021, how the hell did they have it back in 2019 or 2017 before the big DAO guidance, or even back in 2013? That's the kind of argument lawyers love. How will the SEC counter this? It's just the commissioner's personal opinions, and it's an objective standard, and any references to third parties is hearsay. But no matter the argument, all the SEC can do at this point is damage control, and that's never good in litigation. So yes, the SEC is absolutely in damage control, and it's fighting itself, which I rather enjoy, frankly. And I'm a big fan of Hester and Elad, mind you. I just think that they're rather intellectually honest compared to the SECs, which just the SEC attorneys, they just seem really slimy to me, intellectually dishonest and completely unethical and illogical. And so here's the actual document. I thought I had it pulled up. I did have it pulled up. Yeah, here we go. And so this is the one that was filed today, and I'm gonna run through this. Thing's like it's 3 pages. I printed it up and I highlighted the most relevant and interesting points, and I've got a lot to say about this. I've made some notes for myself, which I don't normally do, but I didn't want to forget some of these little Moon Lambo idea nuggets, so I'm going to share those with you. But there we go. We got some dead trees. That's what you're hearing right there. And so the first point that they bring up is the following, right? First, the SEC was established by statute as a commission of 5 commissioners, with each commissioner appointed by the president under certain parameters. Thus, the statement at issue is not a statement of the SEC itself or any sort of binding authority on this court. Essentially, defendants' arguments are tantamount to arguing that they cannot be found liable for violating a statute on the grounds of certain public statements by legislators who disagree with the statute. And so we just have to go back to this idea. And I say all this with a bit of happiness in my soul, because I know that the SEC is just engaging in damage control, as Jeremy Hogan cited here. But like, where does the buck stop effectively? Because again, here we have this is an article, right, written by 2 of 5 SEC commissioners, very high ranking at the SEC, and again, official website here. At what point are market participants what are market participants supposed to look at and take to heart? Where does the buck stop? What does it take for something coming from any high-ranking official at the SEC to be actual policy? That's why I've joked in the past number of times. Does it have to be etched in stone and then put upon someone's mantle? Is that how it actually works here? And so the SEC, they say a bunch of opinions. The highest ranking people at the SEC do, knowing that it's absolutely going to impact market participants, but then they're like, oh yeah, but it's not official, just in case they want to worm out of something later. It's not official policy, though. That's the argument that they're making here, and that's exactly what they're doing. And so what I'm actually going to do here, because there were 5 points, that was number 1 right there. What I'm actually going to do is I'm going to go to point number 5, because it's I can segue perfectly into it, and then I'll cover points 2, 3, and 4. But I want to point out the hypocrisy of all of this. It's just absurd here. Because again, the SEC is saying these opinions right here, it doesn't matter. But still, you have to be like, okay, so but a person of reasonable intelligence, you're telling me that they shouldn't have questions about the SEC's stance on this if 2 of the 5 commissioners don't? And then the argument, they're not even covering the idea of not sufficiently anyway. Are the arguments valid? They're just saying, oh, it doesn't matter because it's a personal opinion. So they're not sufficiently. They do a little bit in this, get into like a small bit of the substance, but they don't really actually dig in because that wouldn't be a winning proposition for them. They really don't here. And so what was so that's the one that was predictable, by the way. That I even guessed that on my channel. I was like, okay, well, I'm willing to bet that the SEC is gonna pull out like the same position that they pulled the idea of William Henman when he was given his 2018 Ethereum speech, giving it legal clarity. Like, no, that was just his personal opinion. Well, they're doing the same thing here again, but check this out. And this is rich. You are absolutely going to love this. Here's point number 5, and then again, I will go back to points 2, 3, and 4. So point number 5, they write, finally, and actually, I'm going to scroll down to it so you can see it. You should see this. All right. Finally, defendants' arguments based on the statement ignore that the SEC itself, through a vote of the 5 commissioners and other SEC commissioners and officials, have repeatedly warned those who sell digital assets to the public of the need to comply with the federal securities laws. And so they're saying that the action itself is the notification. But that's regulation through enforcement, which they also like to pretend like they're not doing. And also, the facts of each case are so drastically different that it's hard to glean anything from them typically. Anyway, sometimes you can. I'm not pretending like you can't ever. Sometimes you can get some interesting stuff. But even then, there's a certain level of ambiguity because they don't have a clear framework here for how market participants are supposed to act. But that's not the most rich thing about this. If you're looking on your screen right now, it's this section right here that I'm highlighting. If you can see that, it's not coming up very bright on my screen. Maybe just for you. There you go, that light blue section that I just highlighted. Look, do you see what they did there? In support of their position here that they have repeatedly warned market participants, what did they do? They highlighted articles with personal opinions, including from the Wall Street Journal. In fact, so there's one right there. Regulators are looking at cryptocurrency, Wall Street Journal. I'm sorry, is that official position of the SEC? Are you telling me market participants are supposed to look at the Wall Street Journal and take that as warning? But then when you go to the official SEC website and you see Hester Peirce and Elad Roisman, 2 of the 5 commissioners here with the SEC that are actually determining whether or not to bring litigation, we're not supposed to look at that and say this is helping provide clarity? So we do look at the Wall Street Journal and say this helps provide clarity for market participants. We don't go to the SEC website and say Hester and Elad's comments here about there being lack of clarity. We don't look there for any sort of official opinion. Do you guys see the hypocrisy here? It could not be more. How did they not catch this? Like, I'm not an attorney. Like, this, like, my gosh, a 5th grader could have caught the illogical nature of this. Like, they have made a huge misstep here in my estimation, right? It's ridiculous. And I mean, they got other stuff too. They've got Jay Clayton and J. Christopher Giancarlo. Regulators are looking at cryptocurrency. There you go. Wall Street Journal. That's supposed to provide clarity? You were just arguing in the same document that personal opinions don't provide clarity. Now you're arguing they do. I can't believe it. You can't make this stuff up, folks. What is this crap? It's hilarious, though. So this level of like nonsense, on top of the fact that the SEC is now effectively fighting itself, it's just you gotta appreciate that. And so that's why, like, even setting aside what is a good legal argument and what isn't, and I can't really typically speak to that because I don't have a legal background, but just as a layperson using my brain, I figure even if somebody's got half a brain, you can see how nonsensical this stuff is that the SEC is arguing here. It's complete garbage and gibberish. Now let's go on to point number 2. Second, and along similar lines, defendants ignore that the Second Circuit long ago held that even the full SEC, quote, may not waive the requirement of an act of Congress, end quote, by supposedly, quote, acquiescing, end quote, to illegal conduct. This is why no defendant in this action has been able to cite, across hundreds of pages of briefing, even one case in the 88 years of the securities laws holding that the SEC may repeal Section 5's registration requirement by a supposed failure to issue a particular kind of regulation or to bring a lawsuit sooner. And so, to me, if anything, this is kind of like just a straw man argument. Who's arguing that? Who is arguing that anything about Section 5 here and effectively like waive requirements of the act of Congress? Like that's not an argument that's being made. And so, look, Ripple is not arguing whether the SEC may repeal registration requirements. Section 5. Ripple is not arguing that. And the SEC is framing it as though that's the argument. That's not true. It's sleight of hand at a minimum. And so, they're arguing that XRP does not meet criteria for registration requirements. That's more in line with what Ripple is saying, that XRP does not meet the criteria for registration requirements. It's not arguing whether or not the SEC may repeal registration requirements. That's not even what's being discussed here. And so this is a little tap dance that they're doing. I don't see how the judge, upon reading this, is going to find that compelling. If anything, at some point, if you're the judge reading through this, it's like you're going to feel like your intelligence is being questioned, like insulting the judge's intelligence. At some point, I'd probably start to feel like that anyway. That's just not even the claim that's actually being made. Now, on point number 3, said the issuer of... Yeah, so this is what they did. They brought up other cases, and that's why there's something like 58 pages of exhibits in addition to this 3-page filing here, which I'm not going to run because it's basically just like the Kick Interactive case, and I think the other one was the Telegram case. And so they wrote here, the issuer of another so-called cryptocurrency in SEC versus Kick Interactive pointed to certain comments by Commissioner Peirce as supporting its argument that the law in the space was unclear. And so they're saying, this was already tried before. Hester's comments, it didn't help win the case. And so here's the deal. The circumstances and specific comments from Peirce in that case are different than what's happening within this case. So let's not pretend like specifics and details don't matter. Let's not pretend that. Let's live in reality. Can we do that, SEC lawyers? That would be nice. And then so, the defendant in that case lost. Yes, we're well aware. I've talked about that on my channel. Kick Interactive, they did lose. But that doesn't mean that this argument is weak or invalid. The idea that Hester Peirce, who is one of the most high-ranking individuals at the SEC, the fact that the defendant in the SEC versus Kick case, that defendant lost, Kick Interactive lost, doesn't mean that SEC Commissioner Peirce's perspective was not valid. It's very valid because it speaks to this idea of what a reasonable person understand whether or not what they're doing is allowed under law. Right? And it's very clear here that there has not been sufficient notice for Ripple. There absolutely has not been. And then on point number 4, let me see here. Here we go. Point number 4, they write the following. Even if the statement were the view of the SEC, which it is not, so they're referencing what Hester and Elad wrote, it is irrelevant to the SEC's aiding and abetting claims against the individual defendants. As the SEC explained in its opposition to the individual defendants' motion to dismiss, the SEC is not required to prove that the individual defendants knew or recklessly disregarded the legal consequences of their actions. And so on this specific point, I am going to have to get perspective from an attorney from the XRP community who can speak to this, because from what I've seen from the attorneys in the XRP community, there's this idea of scienter. You may be familiar with this term at this point. There's this idea that if there's a higher burden of proof, like for conviction for Brad and Chris Larson specifically, because not only do you have to prove that they did something wrong, but that they intentionally and knowingly did it wrong, and so having the knowledge of it, that's called scienter, and so now we're seeing here the SEC, and apparently they brought this argument before, according to this article, which I actually just happened to have not realized, but there's a lot of specifics to the case. I couldn't commit it all to memory anyway. They're saying that that's not the case, that scienter effectively doesn't matter, and that they didn't have to know that what they were doing was wrong. So on point number 4 here, I will have to yield to the actual attorneys to see what they have to say about this. But on the rest of it, I just feel like even if you're not an attorney, you could read through this and just shred it, because it's garbage. And you'd have to be an attorney to figure out the best way to craft arguments against it, because what's legally relevant versus logically what makes sense, they actually are two different things. Not entirely mutually exclusive. I'm just saying, you take a different approach if you're writing a legal argument. But if you're just like a regular person trying to figure out who's right and who's wrong, it's very clear the SEC has just a train wreck of a document here that I've now printed and I'm holding in my hands now. And then I think I have a couple more comments. Yeah, here you go. So Jeremy Hogan actually read through this, and he tweeted the following about this. The SEC dodges the argument. Where does this pleading address the statement and fair notice defense head on? Not once. Because the SEC can't. When you can't argue the issue, dodge it. I've done this before, he writes in parentheses. I would guess that Judge Torres is too sharp for this tactic. So again, the heart of the matter not addressed. By and large, the specifics brought up by Elad and Hester not addressed. But they make a bunch of illogical arguments. I mean, some of this is really rich here. Like, it's just ridiculous here. So this is what we're working with, everybody. Fun times, right? All right. Well, that's what I got for you to this point. I'm sure there's going to be more to say on this as we get more perspectives from the attorneys in the XRP community. I'll be happy to share their perspective on my channel also. I love getting a broad mix of opinions on this, but my gosh, it is the absurdity of all this. It's rather intense. And like I've said before many times, I would much rather be in the position of defending Ripple than defending the SEC in this particular case. That's for damn sure. I am not a financial advisor. You should not buy or sell anything because of anything that I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.